So, you've received a notice to appear, or somebody that you know has received a notice to appear from the Department of Homeland Security. Now what? First of all, what does that even mean? You know, notice to appear, notice to appear. Well, the NTA, as we call it, is the charging document. It's the document that lays out why they think you're deportable. It begins the removal process. You are officially in deportation when they have served the court with the notice. Obviously, they have to serve you as well. And it might not even come in the mail. You know, sometimes with asylums, you've applied for asylum, you've gone to the interview, you're waiting for a decision, and finally you get a decision from the asylum office, and it says, we're referring your case to the immigration court, which is a nice way of saying, we did not approve your case, and you can now go visit a judge and see what he thinks. So in those cases, they're generally mailed, but a lot of times they're actually handed to you. If you get caught up in a raid and you're taken down, your prints are taken. If you were caught entering the country without inspection, you're taken to some place and you're having your prints done, and they're going to have you sit there and wait until they filled out this notice to appear. They'll make you sign for it. But officially, the court has to also be served. And if they're not, you're not officially in removal proceedings yet. Anyway, that's technical. That's for your attorney to worry about. You got the notice. You know you have to appear, and you better show up. All right, so let's go through this notice to appear. Up at the top, it has your date of birth and your alien number. That alien number is actually the number on your physical file, okay? USCIS, DHS, they all share the same file. They send it back and forth. If for some reason USCIS needs the file because there's going to be a marriage interview while you're in removal proceedings, then the ICE officer, the trial attorney, will send it over to USCIS. They're not the same. That's okay. But they'll send it over to USCIS so that they have that file when they're doing the interview. That number is also on any correspondence you get from USCIS or from ICE. It's on your work permission cards. It's on, eventually it'll be on your green card. It'll be on your naturalization certificate. And it should be on every single one of your court notices that you get from EOIR. EOIR, that stands for Executive Office of Immigration Review. Fancy way of saying immigration court. So, up at the top, you see the date of birth. You see the alien number. I need to put my glasses on for this. I had cataract surgery. Now I can see distance fantastic. Can't read for shit. It's very annoying. Anyway, so then they put in, they will identify you. This is terrible. They'll identify you as, what your name is and where you live. In this particular case, this chick was picked up. They accused her of having entered the country without inspection, and they took her straight to Eloy, Arizona. It's a prison. In fact, there's numerous detention centers, apparently, over there. And that's her. That's what they consider her address. So then they get into the factual allegations. It's a fancy way of saying the reasons why they think that this particular person is deportable. It starts with, you're not a citizen of the United States. Then it moves on to, you're a citizen of Mexico. Then it goes into when they thought she entered, which was, I think, October 10th of last year, of 2024. and then they say that she entered without being admitted or paroled, and they are those allegations that they're saying, because of this, we think you're deportable. And then below that is the actual charge. They put in the statute that they think you have violated, and they'll say, you entered without being admitted or paroled. Those things are going to become important. We're going to talk about it a little bit later, but because we're going to have to respond to those allegations and that charge of removability. Then below that, they're going to give you a date, a place and a date to show up for court. Now in this case, she's detained, so it's going to be the court there in Eloy. But most cases that I see are not detained. You have to be so careful to make sure that you have the right date, because who put this date on here to go to immigration court on such and such a date? DHS. Well, they don't keep the IJs. That's an immigration judge. I'm sorry, we're going to use a lot of abbreviations. They don't keep the IJ's calendar, their docket. So when DHS finally serves the immigration court, I have to turn this thing off. Hold on. So when DHS finally serves the immigration court is going to decide when that hearing's going to be. It's probably not going to be the same. Very important that you keep up to date on when your hearing is. You can go into the EOIR's automated case information page, I think it's called. And it's very simple. You just have to key in your A number, and you hit enter, and it will come up with all the information about your case. When's your next hearing, who the judge is, where it is, if there's maybe an appeal pending or something. They'll give you all that information on that particular case information page. So check it and double check it. Check it and double check it. Okay? Because sometimes these things happen and they change dates and you don't know. Related to that is the EOIR 33 form. That's a change of address form. If you change your address, you must notify the court. Period. In fact, I think they only give you 10 days. It might only be 5, but I think it's 10. You've got to tell them. I think in every single one of my videos, this flippin' cat of mine comes over here and starts meowing. She's like, what are you doing down here? And then when I'm repeating it and editing, I keep hearing the cat meowing and meowing. Anyway, I digress. Where the hell was I? Well, I forget where I was, but the change of address. Yeah, you have to notify them, because look, that's in your best interest. You want them to know where you're living, so if there's something happens that changes, you're aware of it. Okay, very important. The most typical reasons that people are put in removal proceedings are that they've overstayed their visa, that they enter the U.S. without inspection, that they have some kind of criminal conviction, even a criminal arrest. Some violations of immigration status, for instance, if you worked without permission. I don't see people doing that very often. However, if you were on an F1 and you worked without permission, that could be a reason to put you in removal. If you're on an F1, F1 is a student visa. If you were on an F1 and you were supposed to be going to, the University of wherever, and you didn't attend or you dropped out, the school is under a requirement to notify immigration that you're no longer enrolled. they can come after you. Okay? So what exactly happens after the NTA is served on you and served on the court? Like I said, now you're officially in removal proceedings. You're going to be scheduled. If it's not this date, double check it. If it's not this date, the master calendar hearing will be scheduled with the immigration court. And that's when you have to do pleadings. I normally do written pleadings. But what are pleadings? Pleadings are your response to this notice to appear. You have to admit or deny each and every one of those factual allegations. Well, you're going to admit that you're not a U.S. citizen. You're going to admit that you're a citizen of Mexico. However, in this particular case, this is a real case. We denied the fact that she entered, what do they have it down here as, October something, right? October 10th, 2024. We denied that because she never left the country and came back. She had been here for years. In fact, she was on DACA. So she'd been here for many. She never left the United States and then re-entered. So they had that wrong. But anyway, you have to, meaning you or your attorney, you have to respond to these allegations. Do you admit them? If you say, no, I didn't enter on such and such a date, then that's the burden then shifts to you to prove, well, when did you enter? Where did you enter? How can you prove that you entered then? So this is another reason why if you're in removal, listen, you need to have an attorney. I just did a whole video about when you need an attorney, and when you're in removal is number one, because it gets kind of complicated. So then you either have to admit or deny. 9 times out of 10, we're admitting them. The only time that I deny something that I think I know is true are the criminal convictions, because it's the burden of the government to prove that she or he was actually convicted. I want them to show it. You have to present your work. I might know that, yes, they were convicted, but they have to prove it. It's on them. And obviously in this case, where they just made a mistake, how they did this, I have no idea. I guess Arizona is a little overwhelmed with people entering without inspection. But anyway, so then the next thing you have to do, then you look at the charge. Now, in a typical master calendar hearing, when we're doing these pleadings, where they caught somebody in a raid. He's been here for 5 years. He had entered on a visa and overstayed. But meanwhile, he's married to a U.S. citizen. They have a kid, another one on the way. It's a valid marriage. They just never got around to filing the paperwork. Well, guess what? Now they're going to get around to it. In a case like that, where you just say, yeah, we admit that he's not a citizen. He's a native of Timbuktu. He entered on such and such a date on a B2 visitor's visa. He was supposed to leave by such and such a date, and he overstayed. Just admit. It's all true. Just admit it. Then you get down to the charge. You either concede it or deny it. In this case, you're going to concede it. So basically, your attorney in a situation like that is basically going to say, yeah, we admit that that she or he is removable, is deportable. In the case I just discussed, his defense is going to be adjustment of status. But before he can adjust his status, he needs to have an approved I-130. The judge does not have jurisdiction over an I-130. He has jurisdiction over an adjustment of status, but not the I-130. So that guy that I was just talking about, married to a a U.S. citizen, a USC, who came in on a valid visa, he can adjust his status if he gets an approved I-130. That's why it's really important when you get this NTA, you need to talk to an attorney like now. Because that I-130, that could take months and months and months. Another possibility is cancellation of removal. Let's say he's not married to a U.S. citizen. Let's say he's married to someone from his home country, but they have 2 or 3 little kids, or even one kid who's under 18, who would suffer extreme hardship if he was not, if he got removed. There's cancellation of removal if he's been here within a certain number of years. So there might be, you're going to renew the asylum application. If you applied for asylum, they referred it to an immigration judge. They'll never say they denied it. We didn't deny it. We just referred it to a judge. You freaking denied it. But you certainly didn't approve it. So anyway, you're going to renew that asylum application in front of we call it an IJ, an immigration judge, right? So so after you've conceded or admitted or denied and did what you needed to do with these factual allegations and with the charge of removability, then you list what your defenses are, and you can have as many as possible. And you also say what's the best language for the person. You also say how long you think it's going to take for you to present your case in chief. And then that's it. But once you've finished with the pleadings, now the judge will give you a date for your next hearing. That can be a year, 2 years, 3 years away. Depends on what city you're in. Depends on how swamped they are. Those dates, again, can also change because sometimes they hire new immigration attorneys, and you think you're living on Easy Street, you've got a 3-year continuance, great. But then they get a couple of new immigration judges, and they have to fill up their dockets, and your case just might go on some new judge's docket. So now your 3-year continuance just dropped down to 15 months. But this first calendar hearing should only take you about 10 minutes. You're going to be sitting up at the table next to your lawyer. It's going to take about 10 minutes. However, expect to spend the entire, if you're in the morning docket, the whole morning. If you're in the afternoon docket, the whole afternoon. Because as I mentioned early on, there could be 20 other people. There could be 40 other people. The hallways could be jam-packed with people waiting to have their little master calendar hearing. So even though it doesn't take very long, by the time you get to actually see the judge yourself, it's probably at least a half a day experience. So eat something before you go there. Then he's going to set the date. I just said that. So what happens when you get this NTA? What should you be doing? I'll tell you what. Number 1, talk to an attorney. Go talk to an immigration attorney immediately. And make sure it's somebody that does deportation defense. Not all immigration lawyers do deportation defense. If they don't cover that type of work, maybe they do business visas or something. If they don't cover that kind of work, I'm sure they're going to have friends that do, so they'll be able to refer you to somebody. Make sure you put that date when your master calendar hearing is on whatever you use as a calendar, so you don't blow the deadline. If you move, I think I mentioned this earlier, if you move, you have to contact the court. There's a particular form, as I said, EOIR 33. And basically, that's going to be a way, it's your defense. You have to prove that you filed this thing, okay? And if they then don't send you a new hearing notice, or they send the notice to the old address, you at least have something to stand on, saying, I did what I was supposed to do. You told me to file this thing, I filed it. So keep that in the back of your mind. If ever you move, you are required to tell them where you are. You know, there's a lot of people on the other side of the aisle from where I sit that they say all these people, they come in, they get hearings, they never show up for their hearings, and blah, 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 blah. That has not been my experience. I mean, everybody knows you have to show up, and a lot of people, like I said, a lot of people have possibilities. Cancellation of removal, if you've been here for a long time, and you've got a good clean record, and you've got either a U.S. citizen or permanent resident, spouse, parent, or child who would suffer extremely if you weren't permitted to stay, you've got a valid case. You've got a possibility. I mean, there are things for people who entered without inspection, that cancellation of removal, you can only do it if you're in removal. I've had many, many people say to me, oh, you know, I've been here 10 years now. How do I file to get my permanent residence? You get your ass locked up and straight that. Let's see. Are you in removal proceedings? No, they don't even know I'm here. Well, guess what? No cancellation of removal for you. You have to be in removal. So, you know, it's not necessarily, I know it sounds horrible, it's scary as hell, I get it, but it might not be that bad. You know, this might be a way when you couldn't convince an immigration adjudicator to approve your asylum case. Now, maybe in the hands of a new attorney who has more experience, who knows the judge, or you have a really great judge, or whatever, I'll tell you what, I was going to say I wouldn't be afraid of going to court, but that's because I've been going to court for 30 years. So, I mean, I get it. It's just very, very scary. But the next calendar hearing, you won't be as scared. And the third time, you won't be. By the third time, if you get 3 calendar hearings just mean they're kind of like, they're just so that the judge, everybody, we all know who's on first, right? What's going on with this case? Like, one of the reasons you might get an extra calendar hearing is because the wife filed the I-130 petition, but it's still pending. So they might call you back in a year. We're checking on that I-130. I-130 still not approved, Your Honor. Maybe you could ask the trial attorney, meaning the government's attorney. Maybe you could ask the trial attorney to explain what the delay is. So it's a time for everybody to see, okay, where are we? What's happening with the case? But if you get 3 of them, believe me, you're not going to be scared. You're going to be pissed off. Another hearing and nothing gets done, and I have to pay my attorney additional money even though nothing got accomplished. So you think you're scared now, trust me. The next hearing you won't be. The third hearing you certainly will not be. However, by the 4th hearing, which is probably your individual hearing, which could be 5 years from now, you should be nervous for that, because that's the big mushbuka. You know, that's the real deal, and that's when you have to really bring your evidence and your witnesses and all that. But that's way down the road. Don't worry about that today. And that's it for right now. It's nighttime. I should go to bed. Hope you have a nice day. See you next time. Thanks.